Welcome to U.S. Government. So in this episode, I'm going to go over a few basic ideas about the judiciary, which is the third branch of the government listed in the Constitution. We hear a lot about courts here in the litigious U.S., so it's a good idea to try to understand how they work. But before we look at the courts themselves, let's take a step back and ask why we need courts at all. Courts have three basic functions in any society that has them. In the first place, they interpret the laws, which, if you've ever spent any time trying to read laws, is incredibly necessary. The second thing courts do is settle disputes. If you've read a lot of pre-modern history, you know that in many places these two functions used to be performed by kings. But because a king is only one man, it's much more efficient for there to be courts to interpret laws and settle disputes. The third thing courts do is create expectations for action. If you know that there's likely to be some kind of penalty for selling tainted whiskey or for cheating on your taxes, you won't do it. Most of the time you hear about laws and lawsuits, people are talking about state courts, but because these videos are about U.S. government, I'm going to focus on the federal court system. The federal court system in the U.S. has four signal features. It's separate from the other branches. It would be possible for the executive branch to perform the functions of courts, like the king used to, but in the U.S. we have a separate branch for that. Federal courts are hierarchical, with the Supreme Court at the top. What this means is that higher-level courts are able to affirm or overturn the decisions of lower-level courts. Federal courts are also able to perform judicial review over laws passed by Congress and the states and over presidential actions. And finally, in the federal court system, judges are appointed for life and their salary cannot be reduced. This is to preserve their independence from the political process. Now you might be confused when I say that courts make law, because you've learned that it's Congress's job to make legislation. And this is very true. However, in the US, as in Britain, we have both statutory law, the laws that legislatures make, and common law, which consists of all the past court decisions that shape our actions in making future decisions. The key to common law is the idea that a court decision sets a precedent that constrains future courts. To simplify greatly, if the Supreme Court says that you can't do X, then all courts below it also say that you can't do X, even if those courts might not think that X is so bad. Here I should also point out basically what courts do. There are two types of courts, trial courts and appellate courts. Trial courts are the ones you see on TV, and they do two things. First, they hear the facts from both sides of a dispute. What qualifies as a fact is constrained by the rules of evidence, which most TV shows and movies ignore because you don't really want to see hours of lawyers arguing over the hearsay rule. After a trial court hears the facts, it decides the case by applying the relevant law. Notice I said courts and not judges or juries because not all trials have juries, and who decides what in a court case actually isn't that important. Appeals courts are where you go if you don't like the decision in a trial court, but appeals courts don't hear facts, they just decide questions of law. Basically, if you want to launch a successful appeal, you need to show that something was wrong with the procedure of your trial. For example, that the judge let the jury hear evidence that should have been excluded. Most of the real laws that courts make are made by appeals courts. I've already hinted at it, but there are two and possibly three types of law. The one most people are most familiar with is criminal law, again because of TV. Criminal laws are statutes written by legislatures, so when you commit a crime, there's an actual written law for you to break. In a criminal dispute, and it is a disagreement because the government says you broke the law and you, hopefully, say that you didn't. The government is on one side, called the prosecution, and the person accused of the crime, called the defendant, is on the other. Almost all criminal cases take place on the state level, although there are some high-profile federal crimes, notably tax evasion, mail fraud, and racketeering. Civil law is the law that you are talking about when you're talking about lawsuits. Civil cases arise from disputes between individuals or between individuals and the government, when one party, the plaintiff, claims that the other party, the defendant, has caused an injury that can be remedied. If the plaintiff proves his or her case, the defendant must pay damages. There are no fines, except maybe court costs, or jail time in a civil case. Contract disputes and personal injury cases are examples of civil law in action. There's a third type of law that is known as public law, and it's kind of a subset of the other two. A case where the defendant or plaintiff shows that the powers of the government or rights of citizens under the Constitution or a federal statute are involved can become public law. This can happen in a criminal case when the defendant claims that his civil rights were violated, for example. And disputes involving the jurisdiction, procedures, or authority of government agencies may become public law if the defendant claims that the government is abusing its authority. So that's basically how courts in general work. In the U.S., we have both statutory and common law, and because of federalism, there are state and federal law. Trial courts hear the facts and apply laws, while appeals courts just decide if the law was applied correctly. We have criminal and civil law, and in either case, if the government is accused of doing something wrong, the case can become public law. The way that American courts are organized structurally and procedurally is a little bit complicated, so we'll discuss that in the next episode. Thanks for watching.